the elements. I mean, could the response just be a referral to the jury
that,
instruction?
It could be, but it would be unbelievably unhelpful if we did that.
Well,
so.
I guess I'm still struggling with exactly what their question is. I mean, they're dependent, yeah.
Yes, exactly. That's why they're asking that, I think.
Your Honor, one other thing that comes to mind is with at least the firearm count, you know, the machine gun is removed, but there's multiple firearms in the house.
Right.
And I'm trying to find what the number was, but in our instructions we had, sometimes there's multiple ways to commit an offense. That specific instruction may aid them if if it's in relation to, sorry, Ms.
Right, if that's what they mean. But
Yes, Your Honor.
considering that, and I can explain that, you know, they don't have to have possessed all of the guns as long as they find that they possessed one of the guns with the requisite intent or whatever, if that's what they mean.
Yes, Your Honor. And the other state's thought on regard to, I do think it's appropriate, and as you know, each individual count they have to evaluate on its own merits. Obviously, these counts relate with one another, but I think that principle of law is.
Well, yes, I mean, yes, they need to consider them individually and reach a verdict on each separately, but they are interrelated counts, so that's why they're asking. So
yes, Your Honor.
I mean,
Shopify's point-of-sale system helps you sell at every stage of your business. Need a fast and secure way to take payments? We've got you covered. How about card?
if their question is regarding the possession of marijuana issue, because that seems to be the thread that runs through these three, right?
Yeah, I think
The only
so.
thing they have in common. So,
And Your Honor, there was one other
but
thought when Mr. Weinstein.
no, I guess I'm still struggling with their question. If the issue is the marijuana, then if they don't find the marijuana, well, obviously they have to find the intent as well.
It's easy enough to start with 58, possession of marijuana with intent to distribute.
Yeah.
You know,
If
I can
that's-
say these are the elements, and they want to understand what intent to distribute means.
I mean, does their question seem to be more if they don't find 58, then they can't find 61?
I think so.
Yeah. And I think that would be maybe what they're looking at.
Yeah.
And then obviously 57, they have kind of two options there, as I see it.
All right. I'm going to. Yes.
Say make it smoother in terms of the surveillance video.
Yeah.
For the barbershop footage, there is 5 videos and really 4 angles. One of them captures the shooting, one of them captures inside the barbershop, and then 2 of them capture the street in front of McDaniel Street itself, but doesn't capture the shooting, and one kind of faces the Texaco. And with the Texaco footage itself, there's a lot of surveillance video from the Texaco with different camera angles. I believe there's as many as 7 or more. So I have an idea in my mind. I don't want to assume which specific portions they want to watch. But for example, some of the vehicles at issue, like when they arrive, some arrive as early as 8:40 or 6:41. And then they leave at 7:20 p.m.
Right.
And so I'm working on, there's different softwares that play those, but the state's getting in a posture to be able to play those surveillance videos. But if we have clarity, at least with the Texaco, it can be a little cumbersome to pull up the different cameras on the fly. So I just wanted to, if there's any more clarity on what specifically with the Texaco, because it captures almost 2 hours worth of footage, some of which is irrelevant for purposes of you don't see any suspects.
Well,
or
I'm sure that they don't want to see a part that they never saw to begin with.
Yes, Your Honor, I agree, but there's also, there's a portion where, there's many different portions that could be relevant. Like there's a portion where Mr. Kendrick walks in the store. There's a portion where different vehicles leave or arrive that captures 50 minutes worth of footage. And so there may be very specific events, so to speak, or times of that they want to watch. But I just wanted to highlight that for the court.
So would the idea be to cue each of them up, the portions that were shown before, and say, do you want to watch this? We could do that.
Yes, Your Honor. Or if they were able to describe an event or something that came up in closing or something to orient what they want to watch. Like we want to see when the Pontiac arrives, or we want to see when, and they may not be able to give that clarity, but I just wanted to highlight that because it may make it more efficient when we publish it.
Ideas on that?
I think if we just ask in a non-leading way, what portion of each, because the same thing, my understanding, and maybe I'm wrong, in the letter, in the note, they said something about McDaniel Street.
Right, it
So-
said, the drive-by shooting, I mean, that one we know what they mean, right? And the Texaco Northside McDaniel Street.
So I think if they, I believe I know what camera they want to see from outside the barber shop, but even with the barber shop, we had 4, I think, different cameras.
So
if we just get clear.
if everybody thinks they know which of each it is and y'all agree, then we can just start with those and say, is this the one you mean, or is there another one?
Okay.
With the Texaco, though, I'm not sure which one they mean because there's so many different cameras at the Texaco. With the McDaniel Street barber shop, I'm pretty
Well, I
confident.
don't think it's the one from inside the barber shop.
No,
That
but
one
there are
wouldn't be
2
helpful.
outside the barber shop.
Yeah.
So, but I think it's probably the one that shows the actual shooting. I'm guessing.
Well, we can start with that one.
Yeah.
And then say, is that the one? There's another one. Would you like to see
Right.
that one too? And they probably will say yes,
That's-
honestly, but
That's fine with that, with the
Yeah.
barber shop. But with the Texaco,
Right.
there's so many options. I think we have to ask them what they specifically want to see. I mean,
what are the, I mean, do y'all want to put a description of each of them together and we can send it out and say, circle the one or ones you want to see? I mean, I don't know how else to,
yeah, I get, because there's kind of an
I
inside
mean,
Texaco and an
describe
outside
what you want to
Texaco.
see seems,
Yeah. I mean, what do you think about the Texaco?
I think there's just an inside and an outside.
No, the Texaco there's multiple insides. Maybe there are multiple insides in the Texaco. Well, we could just ask them, do they want to see the inside of the Texaco or the outside of the Texaco?
okay, I mean, that much we can do.
Yeah. Can I jump back to where the 57, 58, 61?
In a second, Sergeant Brown, can you go ask them to let us know whether the video from the Texaco they want to see is the interior or the exterior? And if they can give us any more detail about what they want to see.
Your Honor, this might help. I'm not certain, but they're probably talking about something from closing. And so if there was a point of reference, like play by
Well,
prosecution,
if
play by
they've-
defense,
Just ask the question that I asked you to ask them.
Okay.
If they want to clarify further, that way they can.
Shopify has everything you need to grow your retail business, like
Okay.
Don't want us talking while
I
the jury
understand.
door is open.
Fi-
Okay.
57, I think I misspoke on 57 where I said there were 2 ways. Rereading 57, count 57. It looks like without the possession of the marijuana, they can't do 57, 58, or 61. So that may be what they're referring to. Because of the possession of a firearm during commission of a felony in 57, requires 58 and 61, which is the marijuana again. So that may be what they're talking about with 57, 58, and 61. Is the possession of marijuana with intent to distribute. Because wasn't there also a question regarding intent that came to us?
Yeah, they originally said, well, no, I'm sorry. On their second one, they said, please clarify the wording intent to distribute and underline the word intent. So I'm looking for where I explained intent to distribute and intent right now, and we'll see.
Page 23.
I'm sorry?
The intent to distribute is defined at the bottom
Yeah.
of page 23.
Yeah. Which they have out with them, so obviously that's not helping them. But
Maybe they just can't find it.
maybe, I mean, I'll read that part over to them.
Of course, I think that's another one of our circular definitions that ended up in here. Or recursive definitions.
So on that, I would propose to say that for, which count is it? Is that count 58 for count?
The possession with intent to distribute, Your
Yeah.
Honor? It's actually an element of
Well,
all
I know,
three.
I know, but so for possession with intent to distribute means that Mr. Kendrick Frankly, if you go back to the knowledge part that I charged on page 13, knowingly and intentionally participated or helped in possessing marijuana, intending to unlawfully deliver or sell it.
Yeah, I agree that that incorporates the
Okay.
proper definitions.
So the state must prove.
Attention retirees, if you're willing to be at your computer from 9 a.m. to 10:45 a.m. on most weekdays, I can show you one simple trade that could potentially...
Your Honor,
Hang on. Sorry, I just need to get this down and then just hold your thought. Let's turn our phones off. Oh, that's one of the jurors' phones. It's in a box over here. Okay, maybe you can go figure out and like put them all on vibrate or something. All right, yes.
part of the instructions the court had read that may be helpful is where it's page 11 and 12.
Okay.
It describes criminal intent. Intent may be shown in multiple ways. Criminal intent does not mean it starts right on the bottom of page 11. Intent is an essential element of any crime. And then I believe it continues to discuss about intent right through the middle of page 12, and then goes on to describe party to a crime. But that instruction about intent could also be beneficial, the state believes.
I mean, the most helpful part of that is it means the intent to commit the act that is prohibited by a statute, which is specifically with regard to this one, intending to unlawfully deliver or sell marijuana. I'm thinking about saying on intent to distribute, possession of marijuana with intent to distribute. The state must prove that Mr. Kendrick knowingly and intentionally participated in or helped in possessing marijuana, intending to unlawfully deliver or sell it. And find out whether that covers what they were asking.
That sounds like the right course to Mr. Kendrick. When you have a second, I just want to go back to 57, 58, and 61.
Sure. I mean, I know we need to get that.
I know, but I don't want to do that if you're still writing
I
or
appreciate
thinking.
it. All right, yes.
Okay. Regarding their question about the separateness and relatedness, whatever term they used to 57, 58, and 61,
Yeah.
I just think it would be, perhaps it would answer their question if you went back and explain that possession of marijuana with intent to distribute is a required finding of each of those three, and that may help explain that.
Okay.
Your Honor, with the court's permission, when the court allows, I have a question.
Hang on.
I want to buy your house. I can pay you cash for your house.
All right, yes, ma'am.
The court may have already answered this question, but I don't know whether what Mr. Atkins just referred the court to was the part about intent may be inferred from the proven circumstances or by acts and conduct. Did the court respond to that?
I'm not planning to read all of that unless when I read the first part and ask them if it covers what they're asking. If they say no, then I'll circle back and read that whole part. Did they get back with us on the video thing? Okay. Do they know to do the light? I mean, they were doing it earlier, all right. All right, let's see. Please provide the videos of the following: the gas station when Yak was getting into the car, camera in front of the station. Y'all understand what that means? Okay, and then number 2, the drive-by shooting in front of the barber shop on McDaniel Street on Donovan Thomas. They clarified that one for us too.
Judge, there are there are 4 camera angles of the drive-by shooting, so we'll be prepared to play one of them or all of them, whatever they prefer. There are 4 different camera angles of the drive-by shooting. I'm presuming they mean the one that actually shows the shots, but there.
I would think so. So let's start with that one and ask them, is this the one you meant?
Okay. Do we?
Yes.
So they added, Mr. Weinstein, also, please have Attorney Weinstein clarify if he said my client's watch or where is the watch regarding the Richard Milley watch, which is in no way, I mean, it's a total red herring. And good for you for distracting them, but that is not an element of anything they're supposed to be considering.
I don't believe that was a red herring, and it went to the credibility of law enforcement
That's
and their
true,
witnesses.
but-
So I would disagree with that characterization
Anyway,
of the court.
what did you say?
I said, I'm sorry, I didn't say his watch. I probably said the watch. If I said his watch, that would have been I would have misspoken.
Okay. So I will just say, Mr. Weinstein did not say my client's watch. If he did, he misspoke.
I probably said, where is the watch that was a gift, a 30th birthday
Where
gift
is the
from
watch?
Drake to Mr. Williams?
All right,
And it
so
rates
I'll just
sentimental
answer
value.
that he said, where is the watch?
Your Honor, would the court be inclined to respond that what the attorneys say is not evidence?
Yes, that's
And
an
that
excellent
should not be
idea.
even a consideration,
Uh-huh.
rather than telling
Yes.
you what he said.
I mean, I'll can do both.
It was definitely the watch.
I'll just say, Mr. Weinstein said the watch. However, what the attorneys say is not evidence. How about that? Does that work?
Yes, Your Honor.
Remember that what the attorneys say is not evidence. Yes, sir.
Your Honor, 292 Yankee Alpha is the shooting barbershop surveillance footage. I know when the shooting happens. I wanted to ask on the record or defense counsel, there is about 8 minutes that plays before the shooting occurs.
Can't imagine that's what they want.
I don't want to just, I want to tell for the record, or agree with defense counsel, find a portion we can all agree to start that video.
Okay.
Yeah, I think it's fine to start a minute before or
Okay.
whatever. That's fine.
Thank you.
But thank you for clarifying that and mentioning that.
You're very welcome. Thank you.
I'm going to say, however, remember that nothing that the attorneys say is evidence.
What's the deal with these ads promising solar panels for free? Well, it's not.
All right, how about after giving them the definition or the explanation of possession with intent to distribute, moving on to whether you need to group counts 57, 58, and 61 individually or separately, you need to consider them individually and reach a verdict as to each separately. But possession of marijuana with intent to distribute would need to be proven for count 58, count 61, and count 57. And I'm putting them in that order because that's kind of the order that 58 is possession with intent to distribute. 61 is possession of the gun because while you're committing that crime. And then 61 is if you're committing that crime, are you then potentially committing gang activity?
Yeah, I understand. That's a far more natural order than they appear in the indictment, so.
All right. All right, are we satisfied then with the answers? And then we'll just have them, I think I'll have them watch the videos, and then answer their questions. Because that way, if there's any follow-up, they can let us know that. All right, yes.
So, Your Honor, the intent is to play the Texaco footage first?
Yeah.
And then will they tell us when they want us to stop? Because they're at the Texaco for about 36 minutes. So what?
Do y'all know when you intend to start? I mean, did we watch 36 minutes?
It was all introduced, every
Okay.
bit of it.
I think they requested a very specific part of that Texaco.
Yeah.
Didn't they mention entering a car or
The
exiting?
gas station when Yak was getting into the car, camera in front of the station. So I think we start there.
Yeah.
And then
When he was getting.
I'll just,
Into the
that's what
car.
it says, when Yak was getting into the car. So, I mean, you know, do a little bit that leads up and a little bit afterwards.
Yeah, let's
and
just play the portion
If
that they're.
it's any more than that, I'll just say, does that cover what you
3
wanted?
times. So do we need
Well,
the
then
last time?
play each time he gets in the car, I guess.
Question: what is the best e-commerce business to start today? Is it drop shipping from China and sell?
Okay, so that's going to be on camera 10, just for the record.
Okay.
And I'm gonna, if the court will give me 1 minute, I'm gonna pull
Sure.
it to the first part.
All right. Do we have the copy, extra copies of the indictment to give them? Have we given them extra copies of the indictment at this point? Sergeant, have we? Okay, thank you. All right, let me know when you're ready and we'll have them out. Get on Zoom.
Your Honor, we have it queued up 296Y at 191633.
All right. All right, let's get the jury in. It went up? Don't worry about it.
All rise for the jury. All jurors are present at county court.
All right, good morning, ladies and gentlemen. The first thing we're going to do is watch the videos that you all requested, and then I'll move on to answering the questions. All right, go ahead with the first one.
Have you heard of turtle traders? They were a group of 14 novice traders who
Excuse me, Your Honor, may we approach?
Yes. Do you want me to stop the video?
Yes, please.
Okay. Give me a second, Bill.
Your Honor, for the record, we're on camera 10 at 18:44:31.
We're not sure exactly which getting into the car you meant, so we're just trying to show all of them for y'all, okay?
So, Your Honor, at this point, for the record, we're going to stop it and stop sharing and then fast forward to the next point that he gets into the car.
Okay.
We're stopping at 18:48:17. We're fast forwarding now to 19:15:25 on camera 10. So that was the second time he got in the car. Now we're going to fast forward to the next time he gets in the car. Okay. Which will be at 19:15:52. We're fast forwarding to that.
One of the great responsibilities that we have is to tell boys and girls, men and women, why the narrow way. Why the narrow way?
An old minister once said in a charge to a young candidate, "Young man, you are called to this church not in the first place to preach sermons or make pastoral calls, but to live among the people the best life you can."
I want to beg you here to consecrate your intellectual powers and your training, your seminary training, to the work of the gospel and the proclamation of the truth of God. I want to beg you to seek to proclaim the gospel as clearly, as cogently, and as coherently as you can, to argue it as persuasively as you can.
Jesus says, now I warn you, it's narrow. And in relationship to secular society, its concepts are narrow, its theology is narrow, everything is narrow about it. With those who are trying to justify themselves of going the broad road, it's narrow. And then he says something that I can testify from my own experience. He says, don't many people travel.
All right, does that satisfy what y'all wanted to see on that?
No, that's not the last time he got in
Okay,
the car.
all right, sorry.
We're fast forwarding.
Sorry, thought y'all said 3 times.
So we're now
My bad.
fast forwarding to 19, 17, and 10. Those are the times that he...
Does that satisfy what y'all wanted to see? Y'all are nodding yes. Okay, all right. Now we'll move on to the barbershop video.
Honor. And for the record, it's 292 Yankee Alpha, and we're starting at 8 minutes and 22 seconds of that exhibit. Your Honor, may you inquire if there's any more of this video? I'm stopping for the record at 9 minutes and 14 seconds.
All right. Does that satisfy what y'all wanted to see on that, or is there a different angle or more that you want to see? That's good. Okay, that's what they wanted to see. All right, moving on. Sorry. Good. Okay. All right, moving on to the questions. Mr. Weinstein said the watch. However, remember that nothing that the attorneys say is evidence. All right, moving on to the next couple of questions. All right, on count 58, possession of marijuana with intent to distribute, the state must prove that Mr. Kendrick knowingly and intentionally participated in or helped in possessing marijuana, intending to unlawfully deliver or sell it. Does that cover what y'all are asking with regard to that one? Yes, okay. All right. Moving on to whether you need to group counts 57, 58, and 61 individually or separately. You will need to consider them individually and reach a verdict as to each of them separately, but possession of marijuana with intent to distribute would need to be proven for count 58, count 61, and count 57. Does that cover what y'all wanted to? Okay. All right, then I will excuse y'all to continue deliberations. Thank you.
For the jury.
Do you know the U.S. Solar
All right, we'll be in recess until we hear from them again. Not for the record, but would it work for? This is not for the record. I'm just asking you as the cameraman. Would it work for
of what looks like Yak Gotti eating Roof Chris steak and lobster meal. But this video was never supposed to be seen because Judge Glanville had suppressed this video. But why did the DA leak this video? Let's begin. I'm going to take you step by step to why this video was released. First, we got Yak Gotti in his cell waiting on his DoorDash order. And this the reason this video should have never been shown to the public. Here why.
And consider the motion to suppress statements of defendant Deamonte Kendricks, and also to take a look at the state's response in respect to those particular assertions in terms of the
jury was never supposed to hear this evidence, and here is why they leaked it. These dirty, rotten scandals leaked this video.
The court has to take into account to determine the voluntariness of a statement. In such, I have considered as well, and will be admitted for purposes of the motion to suppress, Jackson Dental hearing states 1 and 2, Mr. Kendrick's video statements. In particular, the court has viewed a portion of those particular statements relative to the periods of time at 2:16 p.m. continuing for approximately 3 minutes or thereabouts. Also from 2:56 p.m. continuing to about 2 or 3 minutes. And the court specifically has heard in the first video at 2:16 or thereabouts, near the end of that colloquy with the detectives, I need to talk to my lawyer. I don't want to talk no more. And at the second video, starts at 2:56 p.m., goes for about 2 to 3 minutes or thereabouts, and stops at 2:58 and 53 seconds.
Your Honor, may I address the court?
No, I want to make my ruling, okay?
I haven't presented any evidence.
I can take this on argument, and that's what I'm going to do. I'm going to, in terms of the what's been admitted for the court's consideration, that particular portion of the video is what I need to focus on. What I need to focus on is whether or not Mr. Kendrick was in custody, whether or not Miranda was appropriate at that point in time, and whether or not he invoked his right to counsel.
And whether he reinitiated it.
Yes.
You have the officer to talk about that.
I don't need that at this point in time. I really don't. I'm of the opinion. I also had a chance to take a look at Mr. Yohelski sent me as well, and I'm sure the other counsel got a copy of the United States versus Kendrick, both the district court order, which was a hearing in front of Judge Alan Baberman, the United States magistrate, and then Judge Mark Cohen, United States District Court judge. And then the appellate opinion was an opinion based on sentencing. Mr. Kendrick appealed the severity of his sentence. So I'm taking a look at the at the trial court order from Judge Cohen, adopting Judge Baberman's findings.
Right.
And I make it very, of page 2. During the course of page 2, during the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk no more. That is equivocal to this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's, the appellate case law that I've looked at, Paldo and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, I'm not.
Okay, and to your point earlier, Judge Cohen and Judge Baberman, I can't tell whether or not they listened to what I heard, but you're only as good as the information that you're given.
Right.
So it doesn't say on this particular order that that's what they relied upon. It just says he wished to talk, at some point in time, he wanted to speak to his attorney. Now, I'm of the opinion, this court's of the opinion that questioning needs to stop. He's unequivocally revoked. And you can't pick and choose at this point in time whether or not it's to this particular crime or any other assertion. So that's why I'm going to suppress it.
And Your Honor, Your Honor, with respect to the statements that were made after that time, we do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe. It was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence. And since the state has the burden of proof.
Okay, but I've seen the video at this point in time.
The video does not encompass when the defendant actually reinitiated contact.
But the problem is he invokes, and then we don't know what goes on in the 45 minutes, but we come back afterwards, and at that point in time, you don't get to eat your cake, have your cake and eat it too. Once he invokes, that's it. It's over.
Your Honor, that's
they should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about whether or not these statements were made to these set of detectives or to Galpin.
It wasn't there in the room that I'm talking about, Your Honor. I'm talking about in the first, the defendant asked for a smoke. So they took him out for a smoke. When they took him out for a smoke, the defendant reinitiated the conversation as they went outside. That is what they found in the district court, but the court doesn't owe that deference. That is why we have, as a burden of proof, holding the burden of proof, that is the reason we have Detective Thorpe here to testify.
I don't need his, I'll consider it, but it's this court's opinion that once he invokes, you don't get another bite of the apple by taking him outside, softening him up, giving him a cigarette, some bonbons or whatever, and then letting him go ahead and then say, oh well, let me just clarify with you a little bit. Now, that's not that this scenario worked. I think that you all are just annoyed more so that your detective did something that he probably regrets now, and that you all probably would not have told him to do. Don't interrupt this particular investigation or this particular hearing, because what you did is you just now created a wrinkle that now I got to deal with, or whether or not the defendant has invoked his right to counsel. He has.
And Your Honor, I'm not annoyed, Your Honor. I just have, with the burden of proof, we have a person who can speak to the issue rather than having us, sort of speculate as to what happened, because it's not, as the court at this time has indicated that it sees, which is that we softened him up with.
That's my ruling, and prepare an order suitable in my directives.
Yes, Your Honor. Thank you. Your Honor, we have not presented any evidence regarding what happened in the Sally Court. Would the court permit the state to present evidence of what happened when they went upon the defendant's request to get a cigarette?
Ms. Love, I'm of the opinion it's not going to change my mind at this point in time in terms of, because he's invoked, anything after that would be improper. It really would be, because it'd be one thing if he said, well, maybe should I get a lawyer? Maybe should I do whatever this, or kind of make vacillate. But he's pretty significant in the sense of, I need to talk to my lawyer. I don't want to talk to no one.
And Your Honor, our case law shows that even when that happens, when the defendant reinitiates the conversation and communication, that the court has found that those statements made after the defendant reinitiates conversation, as unequivocal as his initial assertion was, when the defendant reinitiates the conversation, the statements that he makes are not to be suppressed. And in this case, the defendant reinitiated the conversation, not the officers. And Your Honor, we've provided to the court, and we have proof. We have actual testimony, given that we do have the burden of proof. Your Honor, Munn versus the state, 313, Georgia 716, says that the court must consider the totality of the circumstances and determine the admissibility of the evidence of the statement under the preponderance of the evidence standard. And Your Honor, given the fact that we have a witness here to testify, the court doesn't have to take my word for it or Mr. Weinstein's word for it. We have the person who was there. The court gets to gauge Detective Thorpe's credibility, and the court then has substantive information and evidence upon which to base a ruling under the actual totality of the circumstances. Right now, we have a clip. When I asked Mr. Weinstein to play for the court, the portion to which he objected, that wasn't the state conceding that we weren't going to put up evidence, Your Honor. I was trying for the sake of brevity to have him point out the part that he objected to, but then that left us without the ability to present anything. And we weren't stopping there. We were just showing to the court where he was arguing the points that he made to us that he wanted to contest. So we would like to present actual evidence to show under a totality of the circumstances.
I got the evidence. It's been admitted. The two videotapes are sufficient for the court's analysis at this point in time. Sir,
That's your ruling. Thank you. I have nothing to add, Your Honor.
And Your Honor, what happened with the Sally Port, the conversation being reinitiated by the defendant, that actually happened, and we have the proof here to show it to the court.
Well, based upon what you've argued so far, in this particular circumstance, this court's of the opinion that once you, it's like this. Once you initiate your right, or you revoke your right to be examined and have counsel, and to have counsel present at that point in time, the courts are very, let's just say, cautious about reinitiation at that point in time. And you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. So, and that's my ruling.
And Your Honor, the thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor,
if you have other evidence independent of this, I'll consider it at the appropriate time.
And we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306 Georgia at 35, Your Honor, Edwards versus Arizona. And, Your Honor, this is a 2020 Georgia Supreme Court case where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point,
I'm sorry, I'm talking, and I don't know why I'm being interrupted. I will not stop. I was speaking.
Ms. Lowe,
I'm sorry, I was speaking.
Both y'all can talk at the same time.
I know, I was
Under the
speaking, and I
state-
expect to be allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
And I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that
Okay,
fact,
no,
but
you
Judge, we
don't.
have
No,
not-
you don't.
Your Honor, we have just not been able to present the evidence.
No, you don't. I
I
get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
When the court says independent basis, does the court mean outside of that video? Because we do have that.
Yeah, if it's not tied to the statement, of course you can introduce it. I mean, as long as you have some independent basis, right? If you didn't get it from his particular statement.
But Your Honor, that's the point, that we have the witness here, that we brought the witness here, and had him cancel medical appointments to testify to the court about. We brought the witness here.
I made a ruling. That has nothing to do with it. That's a red herring, and you know it.
No, Your Honor, I was saying that we were ready to present evidence, and the court is not allowing us to present the evidence. That's all that I'm saying. We have the burden of proof, and we haven't even been able to present the evidence that we have. We only, for the sake of ease, allowed the court to introduce the statements that the defendant made as states 1 and 2 to help Mr. Weinstein play the portion that he wanted to talk about. We didn't even get a chance to play or to have the evidence that the state has ready for presentation to the court to be presented. We should be entitled to present the evidence so that the court actually has the circumstances and does not have speculation or conjecture as to what happened. When the Georgia Supreme Court has clearly said, just as clearly as an attorney being present is required before you consider the statement once he's invoked, the court has as clearly said, if he reinitiates, then that statement can be considered. It does not use them like maybe. It says, if this or that, then the statement can be considered, unless it should be suppressed for another reason. And that case, Paldo, is as recent as 4 years ago. And I'm not just doing this for the sake of engaging in a pattern of behavior, Your Honor. I am standing here emphatically asking that the court allow the state to present its evidence so that the court can make a ruling based on the evidence and not on the assertion by one party or the other as to what should or could be done. We have evidence that I believe that the state is entitled to present and the court is entitled to hear in the form of testimony. And I understand that Mr. Weinstein wants us to hurry it along and not hear Detective Thorpe because that might be an adverse position or evidence to his client's position. But we are simply asking that the court allow us the opportunity to present the evidence and to not hold it against the state that I am asking this, that the court allow us to present evidence that this statement was made voluntarily and that the fact that he ceased it but then reinitiated it is something that the court should consider. And Your Honor, I don't like drawing the court's ire. It's, quite disturbing. But I cannot in good faith not present evidence when we have a whole burden of proof to show the court that it was made freely and voluntarily. And when the evidence that we have is sitting right outside the courtroom. And the court's whole purpose for having these hearings is to determine the truth and to decide what is fair. And without hearing from Detective Thorpe, I don't know how the court can discern what the truth of the matter is, hearing only a portion of a recording and not hearing from the people who were actually standing there talking to and listening to the defendant. Unless without hearing Detective Thorpe, the court is making a credibility judgment before even hearing what he has to say.
May I please speak? Please, may I please speak?
Okay.
And Your Honor, I was asking that the court.
Are you finished now?
I was not, Your Honor. I was
Your
not.
Honor,
Hold on. You got 30 more seconds. Wrap it up.
And Your Honor, I'd ask again the court for the opportunities for the state to be able to present evidence so that the state can meet its burden and not have the court make any kind of ruling based on really partial pieces when the court does not have a totality of the circumstances as a part of the record for the court to consider. So I would ask the court in earnest to allow us to at least present the testimony of Detective Thorpe. If not today, I don't mind doing it. I said in my email to the court and to counsel that we can do this closer in time because he does have or did have that appointment closer in time to when this matter will be right. But Your Honor, I ask that I implore the court to allow us to actually present the evidence that we have to present. I appreciate Your Honor giving me the moment to speak. Thank you.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer, he invoked his right to not speak anymore, and I don't care what schmoozing Detective Thorpe did out at the Sally Port, taking my client off camera. I don't know what went on down there. I don't know what self-serving, well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order. This continued going back whenever the state loses in this case has got to stop at some point, Your Honor. Thank you.
Now for the main event.
I can tell they went from him. They have big ass shirts, like 2004 type shit. Comes to their equal, I'm like, damn. So back 19, walking up to me, I'm like, what's up, y'all like? They ain't saying nothing. They walked at him with Louis Orlando. They had already spread the block, I already had them picked. So by the time they walked at him, I'm like, y'all like? And I said it again. Woody,
Shannon, some other fellas walked through the cut. But they had done called my phone, but I ain't answered. So they were like, yeah, who we bouncing? So I looked. I'm like, y'all watch them. Y'all just playing, watch them.
Correct.
And this thing over. It's just a whole bunch of shots.
So they weren't even trying to rob him?
Shit, they probably was, but it's like, I was around, not around, but it was like other people around me. So they couldn't really just, they walked up on me though, but they couldn't just, they probably had no angle how they wanted to have.
Did they even say like get up or?
They ain't say nothing. Nothing but shots. Right.
And at the time,
No. When I said watch them, all these bad asses pull out their gun and don't shoot. Everybody pull out their gun. Like a draw like.
Like so you said watch them.
Watch them. Everybody pull it out. It ain't like we hang behind that. We right in the middle of the street type shit. Everybody pull out their gun and just get lit. I'm like, hell.
And you don't know when they got shot?
No, hell no. Some innocent bystanders. A lot of folks got shot.
When was this?
Like last one.
Like 2014? Where at?
Iowa Street. Pittsburgh. I shot 5 times.
You did? Did you make a police report? So we went to the hospital, what they said?
I don't want to surgery.
But as a gunshot victim.
So when he got back out, after he did the surgery, he police report they talk to you? Nobody can talk to you?
Cause I ain't never seen this before.
Yeah. Nobody gonna talk to him.
Did the police, they called the ambulance or y'all, they somebody take you down?
Somebody, shit's so crazy that I'm locked over with a dude now who saved my life. I got shot by a crook, and the crook saved my life.
He the one took it off?
I was going out. I just remember him slapping my face. I woke up, I hear you slapping. And he like, you gotta stay up. But he flat, we were like by Turnerville, we had that guy from Pittsburgh, like by Turnerville, almost by the BB. And he flat, police down. Not police, the ambulance. But the ambulance truck was trying to go to the scene, but he flat down.
So you right here?
Yeah.
So Woody done them busted, Shannon done them busted. So when the other guys start shooting, then what? They just what? What do you know?
I don't know. I know they ain't shoot though, but I don't know.
How you know they ain't shoot?
Because I don't want to shoot. Well, you know, that's the first thing. I can't go, I can't die like this. Hell, no. There's a point of everybody hold a gun.
How you got on the gun is skinny though?
For me.
Is it? Where? If you got a bankroll, I get it. That's what you was saying, bankroll is in one. And I guess the handle is up.
No, I want me help. I guess it's on me. You gonna whip my ass up, man.
You don't plan on it?
I ain't standing up there, have to be alive. I'm still here, breathing. It don't look like I got shot 5 times.
I never do.
I know. It was like a redemption. I don't go back to Pittsburgh. I said it took long to that for me to fill out. These not two to be around.
These who?
I said it took more than next week to figure out the names and the dudes to be around.
Who?
Woody, Shannon. The people who dealt with that shot. They're still like ongoing events.
So do you think they was gonna ask you?
Hell yeah. If I got shot 5 times, they was gonna ask me.
So my question is, do you think somebody said it to you, or they just having a plot up and want to rob you?
There's a amount of time they send back road. That's what I think.
But why would you go out like that anyway? That's how you roll.
I'm telling you, I was up at time, loaded.
You still up, ain't you?
I got the right. That shit going down, me being here.
Missed the show, then? You missed the show, then?
Yeah.
You man.
What? Like, hey, my shows went up, so like, that was my first show for that place.
You was the signature act, I guess. Usually what it be with Thug or something?
It be with other artists. It be with Thug, Johnny Stinker. It be with a lot of artists. But it was my personal show.
So what do they do since you had to cancel? Like, how does that work?
I don't know. Most times they send front end, and I got to pay them that, but they ain't send no money. So.
They had enough time.
Yeah.
Did
they knew I was locked up?
That's why I was like somebody informed them that you was locked up. And you might not be able to make it?
Yeah. My sister.
Who? Amina? Which does she employ you?
No, that's my dog, but she ain't, I'm deep for rock with the money. I got a sister who handle everything that she don't handle well and get to it for her. And he like, no hands on. I'm guiding him through the ropes of, you know, management. Like, he's gonna be a man.
Yeah, people for you more stuff for the company.
Yes. He works for me.
So he dang dash.
Yeah, I'm trying to get him.
For you?
Yeah.
So after you got shot, then what was it like? Because you was down for a minute, wasn't you? Once you got shot 5 times, what you down for?
Yeah.
Where did you get shot at? On your body?
Your legs twice. Your legs twice.
Shit, you lucky shit.
Yeah, well, no help?
I never did. Shit, I follow the police reports for you. That's what I'm saying. Like, usually you got shot, you got to make a police report.
They ain't even gonna see me.
They probably didn't know. Or the car probably came in, and then once they got there, nobody was there. Once you got shot at your boy, the guy you said took you and flagged down the ambulance, once the officer got there, they probably thought somebody was hit.
Oh, yeah. Yeah. That's it. Blue, The reason I had money, I don't know, we was gonna go out that night or something. It was the event, I heard. I think I was taking close to $100 or some shit. Something was going on.
But in the beginning, like, if, and YSL, everybody was crew at one point, right?
That's what I'm trying to tell you.
Well, at what point did it start falling apart? Like, it's them and us and them.
I don't know. I can't really say, but I don't know if I was around at the point.
What happened with Jay?
What you mean? At the club?
Period, not that. Just before the club. Because at first it was all y'all together, right?
Yeah, well, when Blood J around, like, I had a spot. And when Blood J, I'm gonna around the same street. I never dealt with, it's crazy, I never dealt with it at the same time. It's like I got my own personal relationship with everybody. And it's like, these niggas, the reason we fell out. You said
You're rocking with them.
You
get by association because they...
It's not even just cutting rock with them, it's just, they play both sides type shit. Like,
what you mean?
Like, who they kill, they squash beef more than one time.
Right.
And soon we get back in the club, yeah, fuck me doing, they throwing money on each other.
So both of them, what, doing the same shit?
They just alike.
They just alike.
They the same.
They the same. Do you
I don't even know
know what they look like?
Yeah.
Do Duke know what he look like?
I'm pretty sure he's smoking.
No, I'm saying, like, does he feel, like, if he saw him in the streets, he'd be like, oh, that's that boy kid.
I don't know.
Because I honestly don't think he knew what he looked like.
He probably don't. A lot of people don't, because like, he just came from nowhere.
And he looks different now.
Right.
He got a big beard, he rocked your boy.
He rocked.
They gave it to him.
They knocked him out.
No, they just gave it to him.
I just stay mad well.
They gave it, like, I can understand why he was so mad because they gave it to him. Whoever he was with. It's just like what you just said. You probably cool with everybody, but that ain't your beef. And that's how they probably was looking. They ain't know where that was coming from because it happened so fast. But he made it a point to let them know, like, he could have snuck him from behind because he came from behind him. But he turned in front of him in his face, like, basically, like, you know who I am? That's what it looked like. He probably
You
said.
ain't playing first?
You know? That's why I say I don't think he knew who he was.
I'm scared. You mean like this, then it's a whole other thing.
What?
Like, that's why I think he knew. I think he's involved in all this shit. I ain't no, I'm not no bella, you feel me? I'm not some little ongoing ride, whatever you want to call it, walk up on and get my undivided attention.
Right. That's why I say to you,
didn't know how you
I don't even think he knew.
You probably look different.
Because he probably was in his
Tell
own,
that video shoot whatever for.
but I think
Yeah, he probably look different.
he probably was in his own zone, in the strip club, whatever.
You'll be too fake piped up.
What you mean?
Too fake turned up, too high wood. For no reason. Yeah, they think he big, yeah. And just too bright. And then that was my dog. I'm gonna say what, cause when I get out, I ain't fucking with him.
Why?
Cause you got me in this shit, bro, and like.
But you was down for the call too.
But like, look, listen. If I was with somebody when I got jumped, he was with somebody.
Right.
I'm not gonna call a whole other person, you know, on, you know what I tell you when I tell you, I'm.
But you said you had to give him the AK. That was your AK. So what gun did you have? You see what I'm saying?
No.
He called you because he knew you was down for that action.
But don't call me for me and that what you need. So I feel like you know
I get what you're saying. I get what you're saying. He basically pulled you into his. But
they ain't coming for yet. I ain't saying they won't.
But it still would have been your beat though. So when they jumped on you at the palace, that wasn't his beat too.
Yeah, he was there.
Oh, okay. So if you was standing on that, would have been his beat.
Hell no.
But if that's your beat.
Well, I ain't.
If you mess with my partner, you mess with me. I'm just saying. I'm dead serious. You know what I'm saying?
I go over the time. Them days be over with.
Man, it's time for all this to be over with.
That's what I'm trying to tell you.
In my opinion, I'm tired of this shit.
I've been tired. That's why I be by myself.
You don't be by yourself all the time.
No, I'm by myself.
I'm tired of it. It's just it went on too long.
I don't come.
How you see it playing out though?
And then what?
Everything, really. Because it's like so much.
Too much.
Too much.
You think you might be telling this shit too much.
I don't understand how y'all get to the point to blow all the way up and out of all of this. And y'all dip back and forth, back and forth.
Who is y'all?
Just as a crew, period. Including like Doug.
Woody.
Oh, all this is Woody.
Yes.
Why you say that?
Because we walk listening to everybody like it. They don't have no one the home to find me. We just go right away or no matter. You look at DK, Mondo who up, the original Mondo war. They weren't just round, just you feel me, like getting into shit, even if they were taking on whatever they doing, they weren't making it like you feel me. No, Woody.
So what you saying, Woody brought too much light?
Too much like. You look at it over Instagram. Too much. He just want to be saying too much, and I seen it. Like a lot of food.
Salute squad. It is I, Mr. Follow Up. Man, again, as always, I appreciate y'all rocking with me tonight. Now, that was your boy there, Yak Gotti, aka Deamonte Kendricks. And they're spilling the beans. This is the infamous video footage that they argued about being redacted out of the evidence. My question is, if the judge said that this video wasn't going to be shown, who leaked it? Who leaked that video? Did the state leak that video? The state was the only one had their hands on it, right? I'm assuming anyway. Nevertheless, I'm out. Squad up.